AJ Armstrong back in court today for a pre-trial hearing. He's being tried a third time on capital murder charges for the 2016 deaths of his parents inside their Bellaire home. AJ was 16 at the time. Now he's 23 and out on a $200,000 bond. He's maintained his innocence through all these trials. The first two ended in hung juries. And now there are a lot of questions about this case as it heads to a third jury. Earlier today, I spoke with Fox 26 legal analyst Charles Adams, who gave us some insight on this case. So, Charles, why is there a third trial? Does that usually happen?
No, you typically don't have a hung jury, right? A hung jury is an anomaly, and it's often considered a win for defense, right? And it's very rare that after a hung jury you'll see a retrial, but this is a high-profile case, and it's a murder case. So you're going to see the state pursuing this until they achieve a verdict one way or the other.
All right. And so what is the prosecution going to do differently, because they've, tried him 2 other times?
Well, that's the big question, right? In the first trial, you had 8 jurors vote to convict and 4 not guilty. And conversely, that ratio flipped to 4 to convict, 8 not guilty in the second trial. And there were some interviews of some of the jurors after the fact, and it seems as if they universally felt that he was guilty. They just felt the state did not have enough evidence to prove beyond a reasonable doubt that he was responsible for the murder. And that's the big, that's the burden of the state. And we've set this up in the United States to try to best ensure that innocent people aren't convicted of crimes by setting up a paradigm where the consequence of the burden of beyond a reasonable doubt does lead to times where guilty people go free. And I think that's the reality here. And unless the DA's office finds a different tact or does a better job selecting their jury, you're going to see another outcome that is focused on reasonable doubt and not guilt or innocence.
And when you talk about the jury, what do you think they're going to look for differently this time around?
Well, when you're selecting from a panel, you have a group, and it's not really a selection process, it's a deselection process. You're seeking to eliminate potential jurors that you think are not going to, in the prosecution's perspective, help them achieve justice, right? So you are trying to find reasons to eliminate them for cause, and then after that you have so many peremptory strikes where you can strike people for any reason but an illegal reason. So you're trying to get a jury that is going to focus on the evidence at hand as the prosecutors, as opposed to listening to the arguments by defense counsel are basically, hey, this might, they just lack the evidence. They can't prove this beyond a reasonable doubt. And that's because while you have the literal smoking gun, they recovered the firearm in the home, you don't have the proverbial smoking gun in this case. You don't have any CSI evidence linking this defendant to the discharge of the weapon or to the weapon itself. So it's a very clear-cut case in the law enforcement perspective that he was the only one that has access, could have been in the house. There was evidence of a use of the firearm as a practice shot in his room. There was evidence that they possibly tried to start a fire before the murder was committed. So they think they have a robust case that establishes that he is the only person that could have done it, and he is the person that did it. But the defense counsel has apparently very effectively pointed out the failures to have affirmative scientific evidence linking him to the weapon.
Charles Adams there with his perspective. Well,